number 26, Bonczar versus American Multi-Cinema. We'll take a moment, counsel, to allow our colleagues to leave the courtroom. Okay, good afternoon, counsel.
Good afternoon, Your Honors. If it please the court, John Collins on behalf of the plaintiff appellant David Bonczar. I would like to reserve 2 minutes for a rebuttal argument.
You may have 2 minutes.
Thank you, Your Honor.
You're welcome.
As the court is aware, this appeal raises two nearly identical questions of law in this construction accident case, which also involves a fall from a ladder, albeit those questions arise under two discrete factual records. The first question is, did plaintiff establish his entitlement to partial summary judgment as to liability under Section 240, Subdivision 1 of the labor law? The appellate division said no, and the case went to trial. And the second question is, when the action was tried, following the appellate division's reversal and denial of plaintiff's motion, did plaintiff establish his entitlement to a directed verdict as to liability under Section 240. And the summary judgment motion, which I'll address first, the relevant facts were drawn in their entirety from plaintiff's deposition. He testified that he was caused to fall when the 6-foot step ladder that he was using shifted and wobbled as he was descending it, causing him to lose his balance. Defendant interposed no evidence contesting
Counsel, I'm going to interrupt you. I'm on the screen. Yes, hi, good afternoon. So I just want to be clear on that 2018 appellate division decision, which is the first one you're talking about on the partial summary judgment motion, plaintiff's partial summary judgment motion. What is the factual question or questions that the majority said needed to go to a jury?
During the course of his deposition, defense counsel asked plaintiff, immediately before the ascent that resulted in your fall, did you check the position of the ladder and check that it was locked? And plaintiff testified that he might have, but he wasn't entirely sure that he did. He did also, during the course of his testimony, say that the ladder was fully open and that he had successfully ascended and descended the ladder several times before the fall incident without a problem. According to the majority's view, that testimony about possibly not checking it immediately before the final ascent raised a question of fact and opened the question, a triable issue of fact.
Okay, but what again, what's the question of fact, not the conclusion of law? What's the question of fact? Whether or not the ladder was indeed properly positioned and opened, because he doesn't know since he didn't check, although I'm not sure that's what the record reveals, but sort of following this line of analysis, or that the fact that he doesn't recall must mean that it actually wasn't positioned and checked and the arms locked.
I don't think the appellate division majority thought that because he couldn't recall it was necessarily either improperly positioned and or not locked. I think the court concluded that because he couldn't recall, there was a triable question of fact.
As to sole proximate cause, is that where it went?
As to sole proximate cause, yes, because if they hadn't found that there was a question as to sole proximate cause, that is, if they found that there was some sort of failure to ensure that the ladder was constructed, placed, and operated that did not, hinge upon the plaintiff's own conduct, then the court, necessarily would have affirmed the summary judgment.
So the factual question is whether or not the ladder was properly positioned and locked?
That, according to the appellate division.
I'm sorry, at that last time that he ascended and descended. I'm talking about that last moment.
That's right. And the descent, which obviously, plaintiff believes had the better of the argument, and the better result was that given his testimony that the ladder was fully open, it would have been, speculative for a jury to conclude that the fall was caused by, the ladder, his not having checked the ladder that time as to, its positioning and or the locking of the arms that hold the ladder open. And I submit that the appellate division dissent was correct, that it was speculative, and that they also properly distinguished this court's decision in Blake versus Neighborhood Housing, which the appellate division majority, found to be persuasive and controlling here. In that case, there was a trial, and the plaintiff testified that he may not have checked the extension clips, which their sole purpose is to hold the ladder, the extension upwards. The extension, the evidence showed, slid down, and therefore the jury was entitled to find that, he was the sole proximate cause. As the dissent in the appellate division held, that's distinct here because an extension ladder can unextend, can retract only if the clips aren't in place, but here there are multiple reasons a ladder can shake and wobble. There are multiple cases out there involving them, and for that reason, the appellate division dissent concluded it was, would be speculative for a jury to find that there was not, in fact, liability here, and that the plaintiff was the sole proximate cause. And for that reason, I submit...
Let me ask you, sorry, over here again. Let me
Yes.
ask you a sort of abstract question. Suppose for a moment there is sufficient evidence to support a jury's verdict for the defense. I know that's not your position. We'll get to the second argument in a minute, but suppose that for a second. And suppose also that you're right, that the appellate division dissenters in the summary judgment were correct. Why would we replace the summary judgment decision with a decision made on a fuller record by a jury?
Because I submit, Your Honor, that if this court concluded that the appellate division dissent had the correct view of it, the appellate division's order was one, or rather this court's decision would necessarily affect that order. The final judgment would necessarily affect that.
Well, why would it? Because the issues were still available to be tried, and you and your adversary were able to put on more and different evidence if you so chose.
I think it would still be deemed a nullity because at that moment in time, what existed was the summary judgment record, and I submit that if the court concluded that that summary judgment record indicated that the trial court indeed had the better view of things, that the dissent had the better view of things, then the subsequent trial would have to be deemed a nullity. It should not have occurred, and basically we are back to where we were when the Supreme Court, granted summary judgment as to liability. And
So, counsel, if I'm understanding this argument in response to Judge Wilson, your position is that the reason that the jury determination should not stand is because it was not fact-finding, it was merely guesswork, which is what the dissent foresaw would be the result of sending this case to the jury.
that certainly is part of it, but I think it goes beyond that because, as Judge Wilson alluded to, there are separate arguments as to why the jury's verdict, even if we assume that the appellate division properly denied summary judgment and remitted the case for trial, why the jury's verdict cannot stand. Going beyond speculation, it enters into irrationality for this reason. At trial, the defense counsel again submitted no proof calling into account plaintiff's trial testimony as to how the accident occurred. And plaintiff, unlike at his deposition, because he was never asked at his deposition, described in detail how before first using the ladder, he visually inspected it, manually inspected and tested it by pulling it apart, making sure that the extension arms drop down. He said when it's fully open, as he opened it, they drop down and are necessarily locked, which was one of the factual questions that was left open according to the appellate division majority. He also said that he placed it and used it at least 4 times without,
Well, counsel, is it not possible that the jury did not credit this testimony given the questioning at the deposition, although it is obvious in the record that plaintiff is trying to explain his answer about not having checked it, right? That he meant only the last time, not any other time. But it's possible, is it not, on this record, that one could read that record and say the jury just didn't believe his attempt to explain the answer at the deposition?
I would say no, Your Honor, for this reason. The defense called an expert construction safety consultant by the name of Daniel Payne, and Mr. Payne did not criticize or in any way take issue with the method by which plaintiff had inspected and tested the ladder before using it, as plaintiff testified to at trial. Rather, Mr. Payne acknowledged that Mr. Bonczar had been provided with proper protection under Section 240, stating, quote, he was provided with a ladder that was adequate and properly set up. That's at page 1142 of the record.
Yes, but counsel, the expert wasn't there when the accident occurred, right? He's saying, so if he did what he said he did, this follows from that, and the jury could have decided as a credibility determination that it was not going to credit plaintiff's testimony, no?
Well, I think that was not the defendant's argument, which was made solely through Mr. Payne. Mr. Payne, in addition to stating what I just quoted, said the question of whether Mr. Bonczar had set the ladder up properly and performed his work isn't the issue. Rather, he said, he's descending, and when the ladder wobbled, he should have maintained and shifted, ladder wobbled and shifted, he should have made 3-point contact. He didn't. He testified that he missed a step, ultimately let go, and fell backwards. For 2 reasons, that position, which is defendant's position at trial as stated by its own expert, is not sufficient to support the jury's verdict. The first is that, as this court has frequently held, most prominently in Blake, a plaintiff's comparative fault is not enough to raise a sole proximate cause issue. And here, when the ladder shifted and wobbled, and the trial court, in its instructions to the jury, which are, on the record and now essentially the law of the case, told the jurors the ladder shifted and wobbled for no apparent reason. And the defendant therefore had the burden of showing that it was either not properly set up or that plaintiff hadn't checked the locking mechanism, and that was the sole proximate cause of the accident. Mr. Payne, and by extension the defendant, said, no, that's not really what the factual question here is. According to the expert, the factual question was plaintiff let go. And as I said, that is nothing but comparative fault, because it's the ladder shaking and wobbling that establishes the existence of a violation of 240. And when the ladder shook and wobbled, people might react in various ways, but if plaintiff missed a step and the expert says, well, he never should have missed a step, if he let go, and the expert says, well, he should have held on as firmly as possible, again, that doesn't establish sole proximate cause. And the second reason that is insufficient to support the verdict, thus rendering it irrational, is that the jury charge specifically instructed the jurors that there were only 2 bases for finding liability on the sole proximate cause on the part of plaintiff. One was that he hadn't checked the ladder's position, and it was in fact improperly positioned. One, that he hadn't checked the spreader arms, and they were in fact not totally extended, and that caused the ladder to fall, or rather to move. The defendant's expert said, no, I concede it was properly set up, and he just should have, maintained three-point contact. That was not one of the bases set forth in the jury charge, and therefore, the jury's finding in conflict with both plaintiff's testimony and the defense theory of the case is irrational and cannot stand.
Thank you, counsel. Counsel?
May it please the court, my name is Josh Kardish. I'm from the law firm of Russo and Gould, and we represent the defendant respondent in this case. And I'm going to say that this case is a reminder of how dangerous it is for a trial court to grant summary judgment to plaintiff on the issue of liability under Labor Law 240 when there are genuine and material issues of fact that only a jury should decide. It would have been patently unfair to the defendant in this case had the Fourth Department affirmed summary judgment for the plaintiff, and we had some sort of crystal ball to see what the jury was going to do or would have done had the Fourth Department done so.
Counsel, what do you make of this argument that the jury trial was a nullity based on the dissent's view that any fact-finding that might take place was pure speculation?
Well, I have a couple of responses to that. First of all, the case law is very, very clear that everything that a plaintiff appellant is mentioning are issues of fact that a jury needs to decide. That's what the Blake case said. That's what the cases that came out of this courthouse, O'Brien in 2017 said, especially in a situation where you have a plaintiff who is claiming that he fell from a ladder but has no witnesses to verify that. At trial, the plaintiff testified that one individual named Justin Drombley, I think his name was, witnessed his fall, but he never called that person to testify. And the Carlos case, which is a Fourth Department case, and other cases say very clearly that when an accident, when there's a fall from a ladder, and there are no witnesses to the accident, a trial is necessary so that the plaintiff can be cross-examined and a jury could make the important decisions with regard to credibility. So summary judgment never should have been granted in the first place.
So counsel, let me interrupt you. I'm on the screen, taking what you just suggested. So let's take the plaintiff gets on the stand, says, I really don't recall. I don't recall. I just don't remember. What is the jury going to base its fact-finding on?
Well, based
And the jury believes, unlike my question to your adversary, the jury believes that the plaintiff doesn't recall. It's not a credibility, well, I'm not so sure that that's true, you said something else previously, right? The plaintiff has been consistent throughout. What fact-finding is going to happen there?
Well, the plaintiff obviously has the burden of proving that there was a violation of the labor law and that...
Yeah, but haven't we already said in the past, if you've got the ladder and the ladder wobbles, the presumption is, and wasn't that the jury charge, the presumption is that there's something wrong with the ladder.
That is not exactly correct. That presumption which the dissent in overturning the summary judgment order mentioned only applies when the ladder malfunctions or is defective and there's no apparent reason why it fell. This court in Blake and in many other
That
cases...
sounds a little circular to me. I'm not understanding your point from that.
Well, there's no...
If one does not know, and there are many reasons why this particular ladder might wobble, right? And the plaintiff said, I don't know why it did that. I have no idea. You're saying you don't get the presumption in that situation? That it must be something with the ladder?
You don't get the presumption when there's no evidence whatsoever that the ladder malfunctioned. Our expert testified at trial very specifically, and their expert, Mr. Doobie, could not refute this, that there was absolutely nothing wrong with the ladder. This is not like a case where the feet are missing or it's bent or something else. The only thing that was wrong with the ladder is that the plaintiff didn't check the positioning on his last time going up the ladder, which our expert said you have to do each and every time. The ladder didn't malfunction, And if the court were to determine that it doesn't matter whether it malfunctioned or not, then it would be violating all the cases that say that simply because a plaintiff falls off a ladder does not create.
Okay, so again, what's the fact finding that the jury's going through? What is it going to decide? When a plaintiff says, I don't recall, it's going to decide that the ladder was either properly positioned and stabilized or it wasn't, right?
So
And if no one's there, except the plaintiff, and they say, I don't recall, what's the exercise of fact-finding that will happen in that kind of a case?
Okay.
Or is your position then the plaintiff never can carry their burden in that example?
Okay, so what the appellate court decided in overturning summary judgment was that there were genuine issues of fact as to whether there was a violation on the defendant's part and whether the plaintiff was the sole proximate cause. And the court specifically stated, plaintiff didn't know why the ladder wobbled or shifted, and he acknowledged that he may not have checked the positioning of the locking mechanism despite having been aware of the need to do so. And that's precisely what the jury found. That was the question of fact.
Yes,
that the
but,
jury determined.
okay, but let's say they believe him when he says, I don't remember, and they decide, no, we think you didn't check it. How does that get you to the fact finding that therefore it is not properly positioned and stabilized?
Well, there were very many things, both at his deposition and at trial, that the plaintiff did not remember. He did not remember which of many ladders in the room he used. He did not remember if he brought the ladder into the room himself, which creates an issue of fact as to whether he set it up himself in the first place. There were a lot of things that the jury heard that he did not remember, so it was very reasonable and logical for the jury to conclude if he remembers climbing the ladder 4 or 5 times with nothing happening, which is another indication that there was absolutely nothing wrong with the ladder, and he doesn't remember that whether or not he positioned it and locked it correctly on the last time, then maybe he didn't do so. And our expert testified that the only reason the ladder fell or could have fallen, well, I'm sorry, the ladder didn't fall. The only reason the plaintiff could have fallen without the ladder falling is if the plaintiff did something or failed to do something that amounted to.
Let me ask you this, if the evidence is that the plaintiff checked at the beginning, but didn't check on the last time, what evidence what would be the fact finding on that? Isn't the fact finding on that then there's something wrong with the ladder if it was properly positioned and locked in place?
No, because for a number of reasons. First of all, the plaintiff testified that in the course of the day, and in his deposition, he said he was up and down that ladder for a fair amount of the day. The plaintiff testified that he left the room for some period of time. When he came back, there was one ladder gone that had been there before. He didn't know which ladder he had used. He didn't remember anything about the circumstances other than the fact that when he started to come down, and Your Honor, his testimony with regard to how he positioned and transitioned his body coming down, this very, very large man on a ladder rated for 225-pound individuals, he didn't remember a lot about what happened. So so these are all the factors and the facts that the jury had to consider, quite consistently with what the appellate division held in overturning summary judgment. These were the very facts that were in issue that the jury decided. And I want to say something also about the verdict. The judge instructed the jury that if they find that there was no violation of the labor law, that they should skip over the question on proximate cause and go to the 4 questions that existed on sole proximate cause. Now, if there's no violation of the labor law, then you don't get to the affirmative defense of sole proximate cause. And what the court should have done is instruct the jury to end its deliberations when it found that there was no violation of the labor law.
And
So
did
we
you object to the form on that basis?
Yes. Obviously, we didn't raise it on appeal because we won summary judgment, the summary judgment order decision, and we also won a trial. But had the jury stopped when it should have, we would not even be talking about sole proximate cause. But The jury did go further and found in 4 separate questions, because the jury found that the plaintiff didn't position the ladder properly, didn't lock the mechanisms, didn't make sure that the legs were extended.
No, I'm sorry. I read the jury form. I believe there were 2 sets of questions. One of them is about positioning the spreaders, 4 questions, and another one is 4 questions about positioning of the ladder. And as to the 4 about the spreaders, there is written a yes, 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 which is then crossed out, and the word skip is notated next to each of those,
No, I believe,
so that it looks to me as if what the jury decided was on positioning only, not on the spreaders.
the jury determined, in question number 3, did plaintiff fail to check the positioning of the ladder? The
That's
answer is
positioning, yes.
Yes.
What about
That's at page-
spreaders?
And then the next one, was the ladder improperly
That's
positioned?
positioning. What about spreaders?
Was yes. Did plaintiff fall because the ladder was improperly positioned?
That's
Yes.
positioning.
Okay. And did the improper position,
That's positioning.
right, okay. Okay, so I stand corrected on the spreader
I just want to
issue.
make sure I read it the same way as you.
Right, it's on the positioning.
Okay.
That the jury, but again, the jury should never have gotten to that point, having determined that there was no violation of the labor law. So, not only did the appellate division rule correctly that these were all genuine issues of fact, but the jury considered all of these points, and the jury made a determination. There is nothing to suggest that that jury determination was against the weight of the evidence or was a product of some insanity on the part of the jurors. The testimony was very clear from the plaintiff as to the fact that he didn't remember positioning the ladder the way he should have. Our expert testified that since the ladder didn't fall, there was nothing wrong with the ladder, and it had everything to do with both the positioning of the ladder and the plaintiff's failure to maintain 3 points of contact, which opposing counsel mentioned. And the point of the 3 points of contact is that the plaintiff's testimony at trial was not clear at what point he lost his contact with the ladder, whether it wobbled and shifted and then he lost contact. In another place during the trial, he said that he misstepped and he missed a step. So again, the jury had to make those factual determinations, and it's our position that the jury did so correctly and that this court should affirm the verdict and also the denial of the summary judgment motion.
Thank you, counsel.
Thank you.
Counsel, your rebuttal?
Yes, Your Honors. I want to address a few of the arguments made by my opponent. He initially argued that because the accident was unwitnessed, there is an inherent tribal issue of fact precluding judgment as a matter of law. That is not the case. In plaintiff's brief, I cite the case of Klein versus New York and Panic versus County of Erie, both from this court, in which the plaintiff was the sole witness to his own accident. And the court in both cases held essentially that in the absence of any proof as to credibility or establishing some question as to whether the plaintiff was accurate, then the plaintiff is nevertheless, even though the accident is unwitnessed, still entitled to judgment, provided that there was a failure to, provide a ladder that was constructed, placed, and operated as to provide protection. It's also irrelevant that the plaintiff could not identify precisely which ladder he was using. The evidence showed that there were a number of trades doing a number of different jobs at this reconstruction, rehabilitation of the theater. He testified that he used a ladder that was in the room, that he set it up, checked it, used it 4 to 6 times. So regardless of who owned that ladder, whether it was his employer, and he said it looked like one of my employers, but I can't be 100% sure, the fact that it shifted and wobbled is what is critical here, not the ownership or identity of that particular ladder. And on that issue, contrary to defendant's argument, shifting and wobbling is the type of malfunction or failure that gives rise to liability. I cite a number of appellate division cases which obviously are not controlling before this court but are instructive. I also cite the Gordon versus Eastern Railway case in which the plaintiff was on a ladder that, quote, tipped. And I think whether the ladder tips, shifts, or wobbles, causing someone to lose their balance and fall, it is a classic, case for the application of Labor Law 240. The defendant also argues that their expert, said that because the ladder didn't fall, plaintiff must have done something wrong. But regardless of whether the ladder fell or simply wobbled and shifted and caused the plaintiff to lose his balance, it's, again, a case for application of 240. And to reiterate, the defense expert said, the ladder was properly set up, and whether it was or not isn't the issue. The issue, according to defense expert and therefore defendant by extension, is that he didn't maintain three-point contact. Again, to reiterate, that was comparative fault at most, and it's undisputed on this record that the ladder shifted and wobbled. The jury was so told, and there is no basis on this record where a jury could rationally and non-speculatively find that the plaintiff didn't properly position or check the position of the ladder, because all of the evidence is the contrary, and the concession by defendant's expert is to the contrary.
Thank you, counsel.
Thank you.